Welcome to this module. We're going to be talking about who is the trustee. The trustee is the fiduciary of the trust. So they are the person who actually carries out all of the bylaws and instructions of the trust. They are also considered the controller of the trust. So they have full control over the trust. They are the ones who do the buying, the selling, the investing of the trust, and they're the fiduciaries for the beneficiaries of the trust. So with the trustees, they can be anyone. So it's going to be like a human person, right? Anyone who is capable of taking any physical possession of a legal title of a property, right? So if you can legally own something, then you can legally become a trustee. So as far as the trustee goes, as far as becoming a trustee, there is no limit to the number of trustees that may be serving on a trust, which means that you can have more than one trustee and that they are going to respect each other and refer to each other as co-trustees, and that they would be acting jointly as a collective body on the board of trustees. Now let's discuss the powers of the trustee. The trustee has the power to bind the trust in a contract, which means that they can execute contracts on behalf of the trust, like let's just say a purchase agreement. And this contract can either be implied by the law or they can be expressed in a physical contract. So they can also have the power to contract with the beneficiaries. They have the power to partition, exchange, sell, pledge, or mortgage the trust property either in whole or in part, which means that they can pretty much have the power to do anything that they want with the physical property or assets of the trust. They have the power to lease the property. They have the power to issue, change, or otherwise dispose of securities of the trust. Also, they have the power to support the beneficiaries in all reasonable manners. They have the power to persecute and defend in the trust name or the trustee's name. They have the power to make gifts out of trust property, which means that they can give a property to a beneficiary or someone else. They have the power to delegate all unessential powers and duties, which is a good thing. So they can actually use authorized members to delegate certain tasks. They have the power to exercise personal judgment and every discretionary power not prohibited by the trust instrument. The trustee may do whatever a man or woman may lawfully do according to the natural rights. Now let's talk about the duties of the trustees. So their duty is to be fully aware of the grantor's original purpose in creating the trust, in that current purpose of the trust, if these have changed over time. So the grantor is the one who is considered the creator of the trust. But in all actuality, you have created the trust, but you have appointed someone else to be the grantor. So the trust has your original purpose in creating the trust. And so the duty is for the trustee or you to be fully aware of that. They also need to guide his or her decision by these purposes to ask so that the actual operation of the trust is empowering to the beneficiaries within the provision of the trust. So if there's any type of discrepancies when it comes to the trustee needs to get clarification so that the trust is operated in the best way or fashion for the beneficiaries. The trustee has the duty to put mechanisms in place to increase the level of financial awareness of the beneficiaries and to see that such financial education of the beneficiaries is carried out effectively, which means that the beneficiaries need to fully understand and be aware of the trust contents, and they need to also be financially illiterate. And they also need to be financially literate when it comes to the trust and the trust funds and certain investments. So it is the duty of the trustee to make sure that the beneficiaries are financially educated. Next, to meet at least annually with each beneficiary in order to renew the beneficiary's understanding of the trust, as well as to obtain from each beneficiary for information, financial and otherwise, his or her personal situation, which means that it is up to the trustee to understand and know what the financial situation of the beneficiary is, to better be able to serve and optimize the trust in the beneficial interests of the beneficiary. So that's why the trustee should be able to meet with the beneficiaries annually to have this understanding and to know that their current financial situation is what it is and not go based off of old information. The trustee's duty is to educate himself or herself about all beneficiary responsibilities, which we'll go over shortly. The trustee should also evaluate and advise each beneficiary on how well he or she is meeting the roles and responsibilities of the beneficiary. So the beneficiary has their own roles and responsibilities, which we'll go over in the next module. But the trustee needs to also be aware that the beneficiary is meeting these roles and responsibilities. The trustee should also be able to implement effectively the trust general policies and procedures as they relate to the following: the trust instrument goals and acceptable risk, the sections and provisions of investment advice, and the management to accomplish such investment goals within the given risk that the trust tax exemption position in the selection of tax services, in the trust legal position, and the selection of legal services. So it is the trustee's best interest and duty to understand these policies and procedures when it relates to investments, when it relates to tax services, when it relates to legal position and legal services, and when it relates to the management of investment goals. Let's go over the privileges that the trustee has when it comes to the trust. So one of the privileges is that the trustee has the right to full compensation, including reimbursement of all out-of-pocket expenses when it comes to the trustee discharging their duties. The trustee has the privilege to reside within the trust estate and allowance of rates and taxes that benefit of residing in those homes. Okay, so whatever house that the trustee owns, whatever house that the trust owns, the trustee has the right to live in that house. The trustee has the right to employ a solicitor for assistance and guidance in the administration of the trust. And In the case of any doubt or difficulty, to seek the opinion of competent counsel, and in the case where the trust accounts are intricate and complicated, to seek the assistance of an accountant to the charge of the trust, which means that we don't expect the trustee to know everything. The trustee is not a specialist in law, a specialist in accounting, a specialist in other services. So it is up to the trustee to solicit those services. So if the trust needs legal representation, then the trustee is going to look for legal services, going to hire a lawyer on behalf of the trust, and is going to be charged to the trust. Another privilege is the right to apply to a court of equity for directions in the execution of the trust, or to obtain a declaratory judgment in order to establish the meaning and intent of the trust instrument, which means that the trustee has the right to seek the court for counsel when it comes to executing this trust, because it falls under contract law. So it is advisable that the individuals who know more about contract law are within the court system and within the legal system. And so since the trustee is a fiduciary and wants to do no harm when it comes to carrying out the mission of the trust, then they do have the right to seek these directions. They have the privilege to carry on in separate business for the benefit of the trust given certain conditions. So when you're carrying out business transactions with a business trust, one of those privileges is that the trustee has full autonomy and is able to do everything that is required to complete that business transaction. They are allowed for loss of time under certain circumstances. For example, if the trustee fell ill and was not able to temporarily carry out the duties, they are allowed to take time off and then to resume the execution of the trust after they are no longer ill. The trustee has the right not to be compelled by subpoenas or reviews to produce or show records or books to outside parties. The trust falls under trust law or contract law, which means that there is privacy policies in place, and one of the fiduciary duties is for the trustee not to disclose the contents of the trust. So one of the privileges is that a court system cannot subpoena the trustee to produce records of the trust. Next, one of the other privileges is the right to further limit his liability, in particular of contracts beyond the limitations made in the trust, which means that the trustee has limited liability when it comes to the trust. And although they can go above and beyond those limited liabilities, they also have the right to further limit their liabilities, because at the end of the day, the trustee is a representator of the trust. They represent the trust, but they are not the trust. They also have the right to relocate, move trust property, or change the trust domicile, which means that they themselves, one, can reside in trust property, they can move to different trust property, and they can dispose of the trust property however they want. They have the right to disclaim the office at the execution or resign at a later date. they have the right to step down as a trustee. Now let's discuss liabilities. So the trustee has the liability on all contracts made, whether signing as the trustee or signing as an individual. So the trustee is the one executing all the contracts, and they have that liability to execute those contracts. They also have liability to remove for breach of trust, waste, mismanagement, or good cause shown in the action for removal in a court of equity or according to the trust. So this means that if the trustee is not acting as a fiduciary or in the best interest of the beneficiary, they do have the right to be removed for breach of trust. They are liable for losses sustained by the trust as a result of negligence. So the fiduciary needs to be operating within the guidelines of the trust, and they are responsible for the trust funds. If there are any losses to the trust funds or mismanagement of the trust funds, then they can actually be responsible for that negligence. The liability for torts and common law, criminal and civil wrongs or acts of bad faith, which means that the trustee needs to be operating in good faith when it comes to them representing the beneficiary and be fully aware of common law, criminal law, and civil law, because if they decide to break the law, they are going to be liable for that. They are going to have liability in all cases of commingling of trust funds, which means that the trust funds do not belong to the trustee. So the trustee cannot pay for private things when it comes to the trust. So they need to make sure that they separate the trust funds. They would be liable also for mischief of any agents that they contract when it comes to exercising discretionary powers. So, for example, if they hired a contractor to do some work on one of the properties and the contractor decides to dash off with the money, then because the trustee contracted that third party, they would be responsible for that loss or the action of that independent contractor. Things that the trustee is not liable for. So the trustee would not be liable for contracts in which the liability was properly limited using the methods to be shown. Such contracts may also compass the codes and statutes of various jurisdictions, given that all man-made laws is by its nature fundamentally contractual, which means that the trustee is not liable for the actual contract content that they sign on behalf of the trust. Next, they're not liable for the debts of the trust incurred during any creditors or in any. Next, the trustee is not liable for any debts that was incurred. Next, the trustee is not liable for any debts that was incurred by the trust related to any other financial institutions or creditors. For example, if there was a credit card issued to the business trust and the credit card was maxed out at $10,000, and let's just say that it was discharged, that is not the financial responsibility of the trustee. And it also works the other way. The trust is not liable for any personal debts of the trustee either. So if the trustee has their own separate credit debt, that has nothing to do with the trust. The trustee is not liable for the independent, non-preventable acts of co-trustees of which he had no prior knowledge. Okay? So each trustee acts independently, but they are cooperating together for the best interests of the trust. Anything that the co-trustee does, the other co-trustee has no liability towards those actions. The trustee has no liability towards the acts of his agents when properly contracted. For example, if the trustee contracted a lawyer and the lawyer the trustee has no liabilities when it comes to the independent, non-preventable acts of the co-trustees of which he had no prior knowledge. So if there are more than one trustee and they're serving on the board of trustees, it is the trustee's obligation to cooperate with their trustee, but their co-trustee, whatever actions that they make, has nothing to do with the other co-trustee. So they are not liable for that person's actions. That person is an independent person and they choose to make their own actions. Next, the trustee has no liability on acts of his agent when properly contracted. So, for example, let's say that they hired an accountant to do tax services and that accountant was properly contracted, then it is not the trustee's responsibility of what occurs due to the error of the accountant. Next, tax on income of the trust. So they are not liable when it comes to income taxes for the trust. They are not liable when it comes to lawsuits against the trust. So to reiterate, the trustee has limited liability. This is the end of the module.